responsibility.
Not any old obligation. I mean, you're absolutely right, of course, that not any old obligation would be enough here. It's an obligation that runs to the individual beneficiary and that concerns an individual beneficiary's entitlement to choose something. And once you're at that, you're at a right. And, you know, if the language in the statute said right, as it did in Tlefsky, you would still say, oh, well, the state doesn't know that right is enforceable. What this language does is the same thing that the rights language does. It says you have an entitlement. It's your option to choose a doctor. Now, you know, we've never said, oh, and the statute has to say, and this can be enforced in court.
May I respond, Mr.
Yes,
Chief?
sure.
Justice Kagan, what you said in Tlefsky is that you need rights-creating language with an unmistakable focus on the benefited class. So the fact that you identify individuals and that they're—
This is an unmistakable focus on the benefited class.
But
the benefited class is Medicaid beneficiaries who have the right to go see the doctor of their choice. That's what this provision is.
But Justice Kagan, it's missing the connective tissue to the rights-creating language. You need clear rights-creating language that the beneficiaries are subject to and that is directed to the regulated entity, here a state, and all of that connective tissue is missing because there are no clearly rights-creating words in this statute. If you would lower the bar, those provisions that we mentioned in our brief are just the start. That's already 10% of Section 1396A. The atypical high bar that you articulated in Tlefsky would be abandoned, and courts will continue discovering rights in all kinds of statutes.
Thank you, counsel. Justice Thomas.